Everyone thought the hearing was winding down until the judge leaned back in his chair, narrowed his eyes, and asked a question nobody expected. The defendant froze. His lawyer stiffened. Even the people in the gallery sat up straighter. It wasn't the judge's tone, calm, steady, almost gentle, that caused the panic. It was the timing. Judges don't ask questions at the end unless they're about to expose the one truth everyone hoped would stay buried. And in that moment, the defendant realized he wasn't being questioned, he was being cornered. Whatever answer came next had the power to end everything.
Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
Counsel, I hear everything. Now, whether react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiffs to rebut what I'm saying.
Oh.
Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was
Counsel,
filed.
I don't know why I need to know all of this.
Because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
so don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tobe.
Yes. Yes.
The courtroom felt smaller, tighter, like the walls themselves were leaning in to listen. The judge waited patiently, hands folded, giving the defendant just enough silence to feel every heartbeat. "Take your time," he said quietly, "but understand, your answer determines what happens next." The defendant swallowed hard. His voice cracked as he tried to respond, but the judge lifted a hand, stopping him. No excuses, just the truth. That single sentence hit like a sentence of its own. You could almost hear the shift in the room, the realization that whatever he said now wouldn't just explain the past, it would decide his future.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted to, I was consulting with her as a property manager. I was not her attorney.
Then if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and
if I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
You were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions. Ms.
Yes,
Tope.
yes.
Whether YouTube or not, it doesn't matter. This is a public record.
Yes.
And all I am telling you is that the court saw concerns.
Yes, and I am here to address the concern so that it's on the record as well, so that.
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish. You may proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No. Right.
So I am done with this issue.
Today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being prejudiced by that. Actions do have consequences, and the consequences of their agent or the actions by tenant's agent have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated, and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action. That's their decision. That should not with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have a management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So,
Was I their property manager?
So
Yes.
it's those statements which give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking writing lessons and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or
do
contractual
it that way. Okay. All right.
No, as a friend.
Okay.
I think Ms. Hope's property company should be a party. She has inserted herself into this litigation. And this went from a simple non-payment of rent and has ballooned because of tenants through their counsel's actions. And it has become a mess.
We filed a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. And you did that. Anything done before that was not in, there was no money put in any trust fund.
Can I just say, so this, let me just ask this. Counsel,
I need to step closer to here.
are you going, we can get the equipment for it.
Very good.
Counsel, are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments and that these are grounds for defaults and that the lease should be terminated and there should be an eviction order. But if we have to keep going this back and forth way, we may have to, especially if it's a third party that's handling the rent funds, then we would have to.
No.
So,
Yes.
were you the property manager for them?
No.
Were you involved in the payment of funds to contractors?
Only in the account that Erica used to withhold her funds. And
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was,
There's our problem.
but not my
Okay,
attorney.
so no. There, that's our problem. So who else was a signatory to that account?
No one else. Me and me alone. And
Okay, Miss,
the money was filed after we filed the circuit court case.
no, doesn't matter.
And this court.
Doesn't matter.
after-
Doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tope? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. But I don't see a legal problem. So when you say a problem,
Let me ask this,
yes.
since you've given that information. And just think about this for a moment.
Okay.
Whether you believe it to be true or not,
Okay.
plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants had done that before they claimed that.
Whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards, but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account.
So if their claim is you can't do it,
Well, I guess.
if their claim is you can't do it,
Yes.
and that the wards could not do it, but then you were the one that did it on their behalf, good, bad, or indifferent, you're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
Okay. Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, is not my issue. You understand what I'm getting at.
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where Ms. Tope, you're brought in as a party and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not, or what position I'm taking. So, Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track for sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenant's agent's conduct by taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks. And my client is going without any rent payments. He got a partial payment, but he is the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.